Well, good afternoon, everybody, and welcome to our McGuireWoods client webinar, Federal Affirmative Action and DEI Update, the end of Executive Order 11246 and the beginning of new enforcement trends. My name is Brian Barger, and joining me are my friends and fellow partners, Bill Doyle and Ned Childs. Thanks to everybody for tuning in. Boy, it's been a big week. Lots of big news about affirmative action and DEI and federal contracting generally, and we have a lot of information to share with you about that. But before we start, let me mention a few quick items about general logistics. First, on your screen, you should see several icons toward the bottom. The resources icon includes a copy of the presentation itself, and if you'd like, you can use it to download it to your laptop, where you can print it out to take notes, or if you don't have time to do that, you'll also receive a link later on with a copy via email. Second, you'll see a Q&A feature. Normally we would do that. We have over 900 participants today, which is fantastic, and we have a ton of information to cover. So we're not going to take questions unless we surprisingly have time. What we're going to do instead is have a session at the very end with a Q&A where we cover most of the common questions that we've already received so far this week. Lastly, please note that the presentation is going to be recorded, and towards the very end, there's going to be a QR code that you can use to request CLE credit. If you have questions about any of that later, please reach out. And speaking of reaching out, as always, our presentation is not meant to constitute legal advice, although Ned and Bill and I are probably your counsel, or if you're not, we want to be. This is not tailored advice. And if you have particular issues or risk considerations that you need to talk through, certainly give Bill or Ned or me or your other McGuireWoods contact a call, and we'd be glad to help you. So with that, let's go ahead and jump in. Last week's executive order, my goodness, about federal affirmative action and DE&I was a massive, massive systemic shakeup. And it creates, frankly, a Rubik's Cube of new legal issues that we're all sorting through, including you. So rather than sort of save sort of the big finish for the very end, we're going to go ahead and cover the three big takeaways we think you need to walk away with right up front. And then we'll just spend the rest of the time talking about the details about why this is and what it means for you. So let's start with big takeaway number one. As you've probably read, most of the burdens, expense, and liability risk that comes from being an OFCCP non-discrimination and affirmative action employer, they've all gone away. Not all of them, but most of them. And that's because it's Executive Order 11246, which we'll talk about in a second, that's gone, which has to do with federal affirmative action for minorities and women. But there are other components of affirmative action that remain. But boy, the risky components, the ones that drive litigation, the one that drives, frankly, recoveries with OFCCP, that has gone away. Big takeaway number two, boy, with that takeaway goes away the regulatory support that comes from being able to do affirmative action as a requirement of federal contracting or subcontracting. That legal cover, as you put it, is gone. Now, there may be other cover with respect to state law, but on the federal side, that cover, at least for Executive Order 11246, has been eliminated. And in addition to that, boy, there's new risks that's created by the executive order related to the DE&I landscape generally, both for federal contractors and non-contractors. That risk, as we'll talk about, has always been there. But boy, the federal enforcement focus has definitely changed. In addition, as for things that have not changed, non-discrimination rules in general are still here. Title VII, the Age Discrimination and Employment Act, the Americans with Disabilities Act, the panoply of other federal and state rules that deal with general non-discrimination, they remain. But the new executive order, which Ned's going to talk about, imposes brand new risks in flow down provisions, especially for federal contractors, which create compliance obligations related to Title VII and how you certify that. And related to that certification, there are new legal risks under the False Claims Act, which are very concerning. So what we're going to talk about is that new executive order that came out last Wednesday, ending illegal discrimination and restoring merit-based opportunity. We're going to talk about what does it cover, what's it mean for affirmative action and OFCCP in particular, What's it mean for DE&I, even if you're not a federal contractor? What's it mean in terms of federal contract terms and other obligations on individuals who are prime and subcontractors? And then we're going to cover the FAQs. So where did this come from? Well, again, it came from that executive order itself. It was issued last Wednesday. There's a link here, and you can also find it on the DOL's website and on the White House website. Related to that, there's a fact sheet, very short, I might say, that the White House put out in connection with it. And we also published a summary that hopefully you've received on our end. What's it address? Well, you know, it has a bunch of different things in it, but there really are 5 top items that it addresses. The first thing it does is it absolutely and immediately revokes Executive Order 11246 and the related sub-amendments that came out related to it over the years. And that has to do with federal affirmative action and non-discrimination regarding women and minorities. It also ends, which Bill is going to talk about, the DOL and OFCCP's investigation enforcement authority immediately over Executive Order 11246. There was some hand-wringing initially about whether that might continue in some form, or whether there's some language in the executive order was meant to sunset it over time. That is not the case, as Bill will talk about, and the executive order 11246 authority is gone. It also creates, though, new federal enforcement priorities regarding DE&I that I mentioned, both for private employers and public employers, especially in higher education. It also does something really interesting. It, you know, not only does it create new risk on that, but it actually tells agencies, and we'll talk about this in detail, but it tells agencies, look, we're not just going to wait for things to hit our door. We're going to actually identify and target for enforcement certain entities over the next 120 days to come back and report to be compiled by the Attorney General. And then last but not least, like I mentioned, and what Ned will talk about, we've got brand new federal contracting risk that's going to be enforced under the False Claims Act. So a lot packed into one fairly short executive order. What's it not do? Like I mentioned, it does not get rid of general non-discrimination, but those laws, by the way, are interestingly enough, have never been enforced by the Department of Labor or OFCCP. So when you think about Title VII, you think about the Equal Pay Act, you think about the Age Discrimination and Employment Act, that's not an OFCCP jurisdiction. OFCCP has jurisdiction in the past over minority and women's discrimination, but only through Executive Order 11246. It has authority over veterans and disabled discrimination and affirmative action, but those are under separate statutes. This executive order does not get rid of these underlying sort of federal rules that remain out there for everybody. The other thing it doesn't do, and Bill's going to talk about this, is it nothing about the new executive order revokes the other parts of affirmative action. So when you think about affirmative action, at least on the federal scale, it derives itself from 3 primary sources. Executive Order 11246, which is a presidential executive order. You live by the pen, you die by the pen, and it died by the pen last week. The other 2 things, though, are statutes. VEVRA, the Vietnam Era Veterans Rehabilitation Assistance Act, and Section 503 of the Rehab Act, which was the precursor to the Americans with Disabilities Act. Those items are statutes, and because they're statutes, they simply can't be eliminated by executive order. Might get eliminated later by legislative action, but nothing about the new executive order does anything to eliminate that. However, as Bill is going to talk about, enforcement of VEVRA in Section 503, at least for now, is on pause. And likewise, what's on pause, it'll be interesting to see what happens to OFCCP's administrative enforcement authority generally over the next few weeks. So that's the intro. With that, I'm going to turn it over to Bill to talk about OFCCP compliance in general. Bill?
Hey, thanks, Brian. So Brian, we're going to do a couple slides here. I looked at the list of attendees, and I think most of you know the landscape of the compliance requirements, but for those who are joining that don't, just a couple slides to give you a background. As Brian said, prior to the revocation of the executive order, the landscape looked like you had the executive order 11246 that addressed non-discrimination affirmative action obligations for women and minorities defined according to the OCCP regulations, and also had broad non-discrimination requirements that, as Brian mentioned, track Title VII. You had Section 503 of the Rehabilitation Act that addresses individuals with disabilities. You have VEVRA, the Vietnam-era Veterans Readjustment Assistance Act, that covers different categories of protected veterans, and those have changed over the years as Congress has modified different categories of veterans based on different types of actions. We have no information or indication that 503 or VEVRA would be modified or changed legislatively. We're not aware of any proposal to do that, and that would be pretty surprising. Now, all three of these authorities only apply to covered federal contractors and subcontractors who met certain dollar amount thresholds and other thresholds and standards regarding whether you're a covered contractor or subcontractor. Didn't reach all private employers, and it was enforced by a unit of the Department of Labor known as the Office of Federal Contract Compliance Programs, or OCCP for short. As we mentioned, the core obligations under those authorities were non-discrimination, and then it mandated affirmative action programs for minorities, women, individuals with disabilities, and protected veterans. The affirmative action programs had a very significant detail of structure that was defined by the OCCP regulation, so it wasn't just kind of this nebulous go to engage in something called affirmative action. Affirmative action meant comply with these very detailed regulations that OCCP published involving what does it mean to conduct affirmative action, what are affirmative action plans. You had to prepare annual affirmative action programs, and they included some detailed but very basic statistical analyses that looked at things like your availability and comparing availability to incumbency, and then doing some very basic statistical analysis like adverse impact studies that were pretty basic, not really the kind of expert level studies that you would see in litigation. These requirements would apply to all of the contractor's employees and not just those, all of those in the U.S. locations, and not just those who are performing on the federal contract. And it included a whole bunch of other obligations. Well, now the landscape is Executive Order 11246 has been revoked. It's no longer in existence. Now it could be put back in place, and we'll talk about that in a bit. But it is effective immediately. It's hereby revoked, and that's not like partially revoked. It's completely revoked. It had this weird language about it requiring OCCP to immediately cease certain things. We'll see that this has kind of become a moot point based on some other developments that we'll get to in some FAQs about the implications of some of these aspects for ongoing OCCP activities. Basically, the OCCP is kind of stopping everything, as is any DOL entity, including the Administrative Review Board, ALJs, the Solicitor of Labor, OCCP. Any DOL employee is ceasing activity on enforcement of 11246. We'll talk about some details around that in some FAQs. Now, there's a provision that says you can comply, and Brian will talk about this in an FAQ about what should you do on voluntary affirmative action programs. This seems to be kind of a 90-day grace period where you can still do like OCCP style affirmative action programs on a voluntary basis before the agency, the executive order is suggesting that those affirmative action programs structured that way would be deemed to be illegal. And then, so what is left, as Brian indicated, we still have the Rehab Act and VEVRA in place. There are still affirmative action requirements, including preparing the plans, making sure you're not discriminating on the basis of those protected classifications, individuals with disabilities and protected veteran status, ensuring reasonable accommodation for disabled veterans and for individuals with disabilities, preparing your AAPs, annual AAPs, which includes, for disability, establishing utilization goals, hiring benchmarks for veterans. You still have the outreach requirements, action-oriented programs. You still have the state job listing requirements for VEVRA, you have record-keeping requirements. We would not expect any of this structure in terms of the compliance obligations would necessarily change, but as we'll talk about in FAQ in a bit, there will be significant changes for the way OCCP likely may enforce these requirements. And that generally would look like, does this move from a affirmative, proactive audit process to maybe just a complaint-driven enforcement process? And that's an open question. So we're going to turn it back to Brian on some really significant issues on the way this new executive order targets employers' DEI programs. Brian?
Yeah, thanks, Bill. So I know we have a ton of attendees, and some of whom may be federal contractors and subcontractors already, and some of whom may not. And if you're not, you may be thinking to yourself, yeah, this is great. Executive Order 11246 is gone, never applied to me, don't really care, don't want to really pay attention, right? You should pay attention for two reasons. Number one, you might be a federal contractor in the future, or you might actually want to reassess your stance and prior decisions on that. Ned's going to walk us through some considerations related to it, but boy, the dynamic in being a federal contractor has changed, and it may be time to sort of rethink that. But secondarily, even if you say, nope, I don't care, I'm not going to be a federal contractor, not one now, will never be one in the future, contractor or subcontractor, you need to understand there are lots of provisions in the new executive order that deal with contractors and non-contractors. And those provisions deal with DE&I in particular. Let's just walk through a couple of items on that. First thing to understand is the law regarding DE&I has not changed one iota based on this executive order. And I've been talking about this actually for years. And you can see this sort of in litigation trends that have arced over the last 5 years. But certainly litigation about these issues have changed, but the underlying foundational legal structure has always remained the same. So for example, constitutional equal protection, Title VII non-discrimination law, and Section 1981 law sort of remains sort of as it's always been. And on the employment side, for example, under Title VII, the law has always been that you cannot use race, gender, ethnicity, national origin, etc., to make decisions in whole or in part based on those protected characteristics. Can't even say it. Those factors. You cannot use those factors to make a decision, right? And that includes things that are bad. I'm not going to hire you because of your race. That also includes things that are good. I'm giving you a preference for A+ to hire you because of your race. Or I'm going to give you an extra score because of race, gender, national origin, etc. Title VII has always worked both in the positive and the negative for the protection of minorities and women and for the protection of non-minorities and men. And nothing about the new executive order changes that. The same thing goes with Section 1981. Section 1981, you don't hear a lot about, but it comes up in employment and contract claims that are employment related and non-employment related. And it has certainly blocks, it deals with situations where race in particular is used to, quote, block the creation of contractual relationships. And this came up certainly, post-Civil War on a lot of different issues. It's certainly a civil rights sort of tool that's been used in areas like housing and banking and all sorts of other important things, but it has implications well beyond that. And that law, again, is not changed at all by the executive order. Now, having said all that, the law and cases about this have been in flux, and you probably read a little bit about that, right? So just as an example, here's two examples, but there are lots more. There's a question about if I want to engage in voluntary affirmative action, where I actually do put my finger on the scale and am allowed to use race and gender, for example, as a factor, even though Title VII prohibits it. When can I do it? And there's a couple of cases out there about it, one called Riki, another called Johnson and Weber. There's been a lot of discussion about whether that law is still good law and whether the Supreme Court will, for example, strike down Johnson and Weber based on some language that they have in Students for Fair Admission. And speaking of Students for Fair Admissions, that's the big case that generated a lot of buzz back in 2023. And for those who recall, that's the Supreme Court decision on higher education, and in particular, the use of affirmative action in education with respect to student admissions. The important thing to understand about that case is number one, it only dealt with student admissions in the exception that allowed colleges and universities to use race and gender in part in a very narrow way in making college admissions decisions. That went away. And when it went away, though, a lot of people said, affirmative action went away with respect to colleges and universities. Well, affirmative action only was allowed with respect to college admissions generally. It was never allowed, for example, with college and university employment, and nothing about affirmative action in the cases that upheld affirmative action in college admissions really changed that landscape. But boy, there was some language in the Students for Fair Admissions decision that sort of gives you a preview of coming attractions about what this Supreme Court thinks about affirmative action generally. And so, for example, it talked about how college admissions and employment was really a zero-sum game. That even though you might be trying to help individuals and be doing really good, positive things in the name of affirmative action and diversity advancement, when you do a positive thing to some, it ends up being a negative to others, and it doesn't always balance out. They also talked about, speaking of balancing, that equal protection really doesn't support the concept of racial balancing. And it also talked about language at length about how diversity as a rationale is problematic legally because it is not, in some respects, focused and in some parts measurable. And they had a lot of language that even talked about, for example, the racial designations under the current EEO-1 form. So there's lots of things that have already been in flux that have nothing to do with the executive order before last Wednesday came upon us. But boy, what did change last Wednesday? The federal enforcement focus has definitely changed. There has been a lot of litigation, which we'll probably talk about in another webinar to follow up on all this, about DE&I generally. So it's been led by folks like America's First Legal and a variety of other groups who have been sort of very actively and systematically attacking corporate America on a variety of different DE&I initiatives. But they've been very targeted. The litigation has been fairly limited. It's been private litigation. You haven't seen a lot of activity from OFCC, for example, or the Department of Labor, or EEOC, or other federal enforcement agencies on that. That is probably going to change. As part of the new executive order that came out, executive agencies were ordered, quote, to enforce our long-standing civil rights laws and to combat illegal private sector DE&I preferences, mandates, policies, programs, and activities. That includes things, in theory, like goal setting. And then it went more. It goes on and says, and by the way, I hereby direct the Attorney General in coordination with agency heads to come up with a report. And part of that report in the next 120 days is supposed to include an enforcement plan related to a variety of different programs and activities related to DE&I, whether it's called DE&I or not. And they specifically called that out. You'll see that in some other things that have come out from other executive orders from administration. They're looking not just at titling, but they're looking at the substance to determine whether certain activities might cross the line into what they perceive to be illegal Title VII discrimination. So how are they going to do that? Well, they said as part of the new executive order a couple things. First, they're going to have what I refer to as activity targets. They're going to look within each agency, not just DOL, not just EEOC, but they're going to do it for the Department of Defense. They're going to do it for the Department of Agriculture. They're going to do it for every executive agency in theory. And each agency is charged with identifying, quote, key sectors of concern within their units. And then within that, they're supposed to propose potential litigation, intervention, and statement of interest ideas, and propose regulatory action and sub-regulatory action to go with it. And then related to it, just an example, in the higher education space, and we're going to have a separate webinar later in February, where my colleagues Farnaz Thompson and Sarah Wake are going to talk about this more. But with respect to higher education in particular, the new executive order directs the Department of Education and the Attorney General to come up with much more detailed guidance than we have seen in the past about the Students for Fair Admissions decision and how that, at least under the new administration, is supposed to be implemented. So a lot more sort of specifics on the nature of the enforcement scope, but it goes more than that. Like I said at the beginning, they're not just going to wait for litigants and complainants to sort of drop on the EEOC's door, for example. The report also directs agencies, and this is a little concerning, to sort of come back and make suggestions about what each agency views to be the most, quote, egregious and discriminatory DE&I practitioners, meaning employers, companies, entities, programs, grants, nonprofits. And they want each agency to come back and suggest up to 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations and associations, foundations with assets of 500 million or more, state and local bar and medical associations. Boy, that hits close to home, right, as lawyers. And institutions of higher education with endowments of over $1 billion. This is not something I made up. This is something that's directly in the executive order. What's unclear, frankly, is whether each agency has to come up with 9 of these, 5 bullets total, or whether they are required to come up with 9 within each sub-bullet. It's unclear about that. But boy, what is clear is that the game is changing on this, and the new administration intends to be fairly aggressive about both how they interpret the scope of what is a violation in connection with DE&I, and sort of what they're going to do to sort of track that down in the public and private space. So with that, before we get to Q&As later, I'll turn it over to Ned to talk about new developments in federal acquisition in general.
Great. Well, thank you, Brian. And I'll try to get through this fairly quickly here so we can get over to the Q&A. But the executive order here does make some fairly important and significant changes with respect to federal contracting issues that contractors are going to need to be aware of going forward, much of which remains subject to further implementation guidance that we expect to be forthcoming in the fairly near future here. So what does the executive order do? So at its core, the EO requires that every agency that is awarding a contract, or every contractor or grant that's awarded by an agency, must include 2 particular terms. One, it requires a contractual counterparty or grant recipient to agree that compliance in all material respects with all applicable federal anti-discrimination laws is material to the government's payment decisions for the purposes of Section 329B4 of Title 31 United States Code. That's the Civil False Claims Act. As we'll get into in a second here, that is fairly important from an enforcement standpoint and checks the box and gives the government a significant amount of leeway in demonstrating that a claim is material for the purposes of False Claims Act enforcement. Second, the executive order requires each counterparty for a grant or a federal contract to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. Again, this is a significant this is a significant change from past practice, and we expect this will be implemented through the system for award management over the course of the next number of months here. So what does this mean from why is this a big deal? What does this mean from a terms and certification standpoint? So both of these terms, given that what has been required here, will likely be actionable under the Civil False Claims Act. So the civil FCA, civil liability attaches where a person knowingly submits or causes another to submit a false claim to the government for payment. This dates back to the Civil War. It's the government's core anti-fraud recovery mechanism, enforcement mechanism with respect to federal contracting. Over the past number of years, it has also become an area where the definition of fraud and the definition of breach of contract have started to overlap to some extent in what's known as the implied certification theory of enforcement under the False Claims Act. And that's where the risk associated with these certifications are going to come into practice. Another key element of the Civil False Claims Act is that it's not just the Justice Department, at least as of now, and there could be some case law coming down the pike on this in the not so distant future, but at least under the current iteration of the Civil False Claims Act, qui tam relators, whistleblowers are also entitled to bring claims in the name of the government under the federal Civil False Claims Act. So there is significant incentive for employees at federal contractors to disclose misconduct, fraud, breaches of contract that would be violative of the civil FCA. So what is an example of a potential FCA claim that could be implicated by the executive order here? So, and this would be a fairly sophisticated example from a Title VII standpoint. I'll get into a more basic example in a second here, but sophisticated plaintiffs' counsel under the new executive order can theoretically bring a Civil False Claims Act action against an employer engaged in widespread hiring discrimination over the past 6 years. This includes such things as alleged DEI-related diverse slate interview practices, non-DEI general EEO-related disparate impact, statistical evidence violations. Things of that nature are now likely to be actionable under the Civil False Claims Act. Unlike the Title VII, however, there's no class certification requirement. As is typically the case in a Title VII class claim. The jurisdictional period for filing a Civil False Claims Act claim is significantly longer than that which is required under Title VII. It's a 6-year statute of limitations. So the look back is significantly longer and includes a significantly broader liability tail from a risk perspective. From a discovery perspective, same issues is going to be at issue under Title IV. Going to focus on corporate leadership's knowledge of the alleged practices and disparities at issue. That's from a sophisticated plaintiff's counsel standpoint. We could see situations where qui tam relators at the employee level that are aggrieved because they have not been promoted, that their company has a DEI practice or program that they believe is inconsistent with the requirements under federal law. It incentivizes their disclosure of those particular alleged practices, and as a result of that, they do get a piece of the pie. There is a relator share through the qui tam program that the relator is entitled to some element of any proceeds that the government receives, as well as to collect legal fees in connection with any successful False Claims Act claim. So back to the basics of what is a Civil False Claims Act claim. It's a claim by the defendant submitted to the United States that was materially false or fraudulent. So under, like I said, what's known as the implied certification theory, a contractor's breach of contract or regulatory requirements can be grounds for False Claims Act liability if it is material. And what that means is that the breach of contract has a natural tendency to influence or be capable of influencing the payment or receipt of money or property. Was originally, it came up through the DC Circuit, and eventually it's a case of the SAIC case in the mid-2000s, and then it was legitimized by the Supreme Court in Escobar in 2016, which held that the implied certification is a viable theory, but did add some degree of rigor to the materiality review, holding that The materiality standard is demanding, and assessing materiality requires a rigorous review that focuses on whether the government received the essence of its bargain. So it's twofold here. One, did the failure to comply with the underlying contractual or regulatory requirement have an impact on the government's ability to decision to pay? Stated differently, if the government was aware of a non-compliance, would it have paid the underlying invoice? And then in addition to that, does that particular element, does that particular breach violate the essence of the bargain that the government received in contracting for that particular service from the contractor? As we'll get to in a second here, the language in the executive order saying that compliance with Title VII, compliance with federal anti-discrimination laws, that is material to the government's decision to pay under any federal contract. That, to some extent, can be interpreted as indicating, or at least signifying here, that the administration is signaling that violation of those particular statutes and requirements here is going to be sufficient to satisfy that materiality element of a civil False Claims Act claim. Now, lastly, from a mens rea perspective, the defendant's conduct must be knowing, which is frankly not a particularly high bar. It's actual knowledge, reckless disregard, or deliberate ignorance. If there are facts that are out there that can be known by management, known by the company, that indicate that a claim that this conduct is occurring, that there is a breach of contract, that you're not complying with the regulatory guidance, this is the type of thing that would be actionable under the Civil False Claims Act. So FCA damages, penalties, and other risks. First, there's two different types of remedies under the Civil False Claims Act, and they are non-exclusive. So the first of these, recovery can amount to 3 times the actual damages that the government has sustained. That amount of actual damages, it varies depending on the circuit. It varies depending on the nature of the claim. And it doesn't necessarily mean in the context of, did the government receive a defective part that is worthless? Did a contractor overcharge for services that were rendered? Did the contractor bill for commercial services under a federal contract? There's some case law that is out there that indicates in other contexts where the entrance into a federal contract is predicated upon the satisfaction of certain regulatory requirements. So a small business set-aside contract, for example, the benefit of the bargain associated with the entrance of that contract, if a large business is awarded a small business set-aside contract, the actual damages can actually amount to the full value of that contract because the purpose of the underlying regulatory regime is violated by the fraud that has been committed on the government. There's also case law that's out there that says if there are no actual damages, the number can be 0. And the issue with that under the Civil False Claims Act is that there's also a civil penalty provision of the FCA under which the government can seek between $14,000 and $18,000 per claim per invoice that's submitted to the government, regardless of the actual damages that are sustained under that particular contract. So that may not seem like a large deal to the extent that a contractor is submitting 1 invoice to the government a month. We have seen examples, for example, however, under things like GSA contracts where contractors are submitting a large number of very low value invoices to government agencies in upwards of 600-700 invoices a week. That number can get fairly significantly reach 8th Amendment issues there as well. But just given the nature of the penalty provision there, and again, those are non-exclusive remedies. In addition, as I noted, from a whistleblower perspective, claimants are generally entitled to between 15 and 25% of the total settlement cost if the government intervenes, more than that if the government does not intervene, as well as attorney's fees and costs if the claim is ultimately successful. So again, there is an incentive for whistleblowers to make claims if they are deemed eventually successful. They do get a piece of the recovery as well as their fees and costs back. Outside of the civil context, there's both criminal enforcement risk. There is a Criminal False Claims Act as well. higher standard of proof from a violation standpoint, but then also debarment risk for failing to disclose violations of the civil FCA under both FAR 9.406 and the mandatory disclosure rule FAR 52203-13. Again, there's a 6-year statute of limitations here. There's certain ways that statute of limitations can be extended out to 10 years. So this is a risk that is not static in time. It doesn't go away in short order, and it can go out into the future for a fairly significant period of time from a liability standpoint. So how will these terms and certifications be implemented? So the rep and warranty provisions that are expressly provided in the executive order here provide an upfront agreement that these terms are material. As I noted before, that's a fairly significant issue. It has been litigated fairly extensively under the Civil False Claims Act. So that can check the box from an implied certification standpoint. It also risks treatment as an express certification as opposed to an implied certification, which again can in and of itself be actionable under the False Claims Act outside of that implied certification theory. We're likely to see updated SAM certifications related to both federal prime contract bidding and both grant awards and subawards. This is obviously not contemplated under the current SAM reps and certs or the OFCCP regulations, so we do expect that will be coming down the pike in fairly short order here. Any updates to the FAR is going to need to be subject to notice and comment process. Now, that said, once those proposed rules are issued, we do expect potentially to see FAR deviations issued by agencies, given the interest in it from the administration here, that seek to implement some of those requirements sooner than may be required under the notice and comment process. So again, it's something to be aware of and cognizant of on a going forward basis as additional guidance is forthcoming from the administration here. Now, new federal contracting and enforcement targets. Here, as noted here, the government is going to be looking at not only federal contracting in the revocation of the EEO and Affirmative Action Plan executive order here, but in accordance with Executive Order 13279, the employment, procurement, and contracting practices of federal contractors and subcontractors, so this is not just the prime contract level, but subcontractors, shall not consider race, color, sex, sexual preference, religion, or national origin in ways that violate the nation's civil rights laws. Again, this is going to be something where we expect significant comment and guidance from agencies, but we view this as having a fairly significant risk from a supplier diversity program standpoint, from a supply and service offering standpoint, as it pertains to the banking and financing industry. We view that there's a significant risk to some of the SBA's diversity contracting programs that are administered, and we do expect over the course of the next number of weeks and months here for there to be additional action there, both at the executive order level and with respect to specific guidance that will be issued by agencies in connection with each of these issues here. So with that, I will pass it back to Bill and Brian for FAQs in connection with the executive order here.
Thanks, Ed. So as we said earlier, a placeholder about the FAQs, we have a series of FAQs that answer a lot of the questions that we expect you're having about this. So the first question is, how does this rescission of 11246 address ongoing OCCP audit activity? And as Brian mentioned, there was for a couple of days, there was a little question mark as to what that meant. But that was all resolved late Friday night or late Friday evening when the acting Secretary of Labor issued a Secretary's Order 03/2025 called Cease and Desist Everything You're Doing. It went to every DOL entity that has any interaction with OCCP. So that would be the Solicitor's Office, that would be the Administrative Review Board, that would be involved in deciding OCCP administrative litigation. It went to the Office of Administrative Law Judges. It went to OCCP personnel. And so basically said, cease everything that you're doing of any current audit that is looking at 11246, any conciliation agreement, basically any enforcement activity, and it listed all the kind of different modalities of enforcement activities. You can read the order itself. Just Google it, you'll see the order come up of what those different modes of enforcement are. But basically it's everything, and it stops for 11246. You're supposed to send out letters by January 31st or emails that basically says that in a pending audit that the 11246 components, meaning race, gender, women and minority APs, all the things we talked about earlier, will be closed. And then for the pending audits, the Section 503 and VEBRA requirements and investigation will be held in abeyance until further guidance. That goes to the question of, well, they could choose to start to enforce 503 and VEBRA in a different way, like through a completely complaint-driven process. So we don't know what they're going to do. They're going to be figuring out what they want to do, and that's something that why they're saying it's going to be held in abeyance. So next one, I think, Brian.
Yeah, I'll take the next one. So we talked about sort of what's OFCCP said about this. So as Bill said, they issued an order, or the acting Secretary of Labor in particular issued an order, a stand-down order Friday evening. EEOC has not made a similar statement yet about their own sort of enforcement activity per se. That's in part because the commission is not like the Department of Labor. The commission is actually sort of made up, or the commission itself is made up of appointees that are both Republican and Democrat. They have staggered terms. There is a new Republican chair, Andrea Lucas, but they do not have the votes yet to sort of be issuing a lot of directives until one or more of the Democrats' terms roll off. Having said all that, boy, the EEOC chair did come right out of the box last week and issue a statement that said, I look forward to restoring even-handed enforcement of employment civil rights law for Americans. In recent years, this agency, i.e. EEOC, has remained silent in the face of multiple forms of widespread, overt discrimination, consistent with the President's executive order and priorities. My priorities, i.e. as chair, will be include rooting out unlawful DEI-motivated race and sex discrimination. So as we mentioned before, even though this may not have been a very high priority issue under past administrations with respect to agency enforcement, EEOC, at least the new chair, is going on record to say it's going to be part of my focus. And likewise, what we expect the agency as an entity over time to be sort of directed at. So that's a big change. Ned, what about the next question?
So what if any word have we heard from federal contracting authorities? So on January 22nd, policy statement to GSA contractors from the acting administrator of the GSA regarding the intent to suspend enforcement of contractual DEI terms and existing agreements, posted to SAM, like I said, on January 23rd. It was dated the 22nd, issued on the 23rd. So this guidance from the GSA administrator says that the forbearance related to these DEI-related terms may include, but is not limited to, any clauses that mandate diversity-related obligations, any reporting or record-keeping requirements specifically related to the same, and to requirements imposed on contractors on a firm-wide basis, in each case not otherwise mandated by law. So the GSA, one of the heads of the FAR Council, administrator of the GSA, has already indicated from a GSA standpoint that they are taking this seriously and will be taking significant action in the near term to be removing or forbearing enforcement of clauses that are related to DEI terms. We certainly expect to receive similar direction from the Defense Department and other federal contracting agencies in the near term. The GSA guidance also provided that additional guidance and direction are forthcoming in the near term. The guidance and related issues are coming out on literally a daily basis here, as many of you may know. Late last night, the acting head of OMB released a memorandum to all agencies holding the issuance of federal funding to any organizations over the course of the next 10 days while agencies are undergoing a review of the specific terms of each of those federal funding agreements. for issues that are in line or not in line with the administration's policy perspectives. This expressly includes issues such as DEI, Green New Deal, issues of that nature. So these are these things are coming out on literally a daily basis here, and as a result of that, we do expect to see additional guidance both at the regulatory level, at the executive order level, and then down also at the sub-regulatory level as well. As I said, as suggested here by the GSA acting administrator's statement.
So this one is mine. It's very quick. The answer is no. It's 11246, as we said, is not in effect. It's no longer in effect. Nor is OCGP's enforcement of that. The 90 days came from the provision in the executive order that confused some people in terms of thinking that maybe OCGP's enforcement activity would continue for 90 days. And that was not the intent. It was to give a 90-day grace period for contractors to continue their, on a voluntary basis, their 11246 APs, with the concept that the White House expects those will be winding down over the 90-day period, and that's kind of the intent of that 90-day provision. Brian?
Yeah, another quick item. I know we're trying to keep us all on time here, but any guess on how DEI target enforcement will start? Yeah, we have a really good guess. If you think back to the end of the Trump administration, the OFCCP actually sent out sort of agency directive orders and letters to targeted large employers, wondering about how they set up their DEI goals and how they thought they were going to achieve those goals within such a short time frame as published without violating Title VII. So these were sort of agency-directed letters, agency-directed sort of requests for information. Certainly, OFCCP won't be doing that under Executive Order 11246, for example, because they had no more authority to do that. But do we expect to see something like that, for example, coming out of the EEOC? You bet we do. Why do we think that? Well, America's First Legal and other plaintiffs groups have already been requesting that of OFCCP. If you want to see a sample of what that is, they put it on their website. You can look at exactly what they've been doing. In the past, they have landed at the EEOC with a thud, and there's been not a lot of agency attention to that. We think that will be changing. And likewise, like we mentioned before, you need to be careful about this. Simply rebranding certain types of DEI efforts won't do the trick. They're going to be looking for those changes as well. So on class action risk, Bill, you want to talk about that?
Yeah, so just quickly, educated guess. I mean, we're seeing a very high activity of class action risk already, targeting kind of the larger claims that where very sophisticated plaintiffs firms are bringing kind of very large value claims that then are settling for typically over $25 million. And you've seen them in the news and the trade journals of all these settlements, even over the last couple of years, some pretty extremely large settlements. But the concept here would be that this OCGP really operating in kind of the mid and lower tier level of claims, maybe those between, a couple 100,000 and a couple million. And you could see this presenting an opportunity now for some class action firms, maybe not the most sophisticated ones who are occupied by the bigger cases, but the firms that want to get into that space a bit would have an opportunity to go after more mid-size, more discrete, focused class claims that would be available now that OCGP really isn't in that business. And the concept would be to think about, well, based on that, increased existing risk of the large-scale classes, increased risk of the medium, smaller class type cases, whether it makes sense to consider repurposing some of the resources that were devoted towards the affirmative action program and that sort of OCGP compliance to more kind of legal risk assessment around this type of expected claim like this. And it could be state enforcement actions under state fair employment practice laws that we expect to increase as well.
So we've been a little bit doom and gloom with some of the issues here. I think there's one possible positive here, at least on the federal contracting side. A good number of clients of ours have historically tried to stay out of the federal contracting space because of certain of the affirmative action EEO obligations that are attendant to being a federal contractor under the now rescinded executive order. Those challenges are now gone. The systems and staffing, vendor, and other costs that are associated with being a federal contractor in connection with affirmative action, those are no longer present, at least in a large part outside of the two limited classes that remain subject to the statutory authorizations. Same thing with liability audit exposure. Outside of those limited classes, that liability audit exposure no longer exists. Now, one thing to be very cognizant of here, as companies are considering getting into the federal contracting space, one, because this is done by executive order, it is possible that, and potentially likely, depending on what the next administration may be, that these types of requirements may snap back under future administrations. Now, that does not necessarily mean that a company that has a federal contract in 5 years, if the regulations snap back, if the EO snaps back, that they will immediately need to be compliant with these particular requirements again. Any changes to a contract technically need to be implemented via the contract's changes clause. Saw this in the COVID clause litigation that happened back in 2020, and certain of the compliance issues that arose out of the administration's attempts to require federal contractors to vaccinate their employees against COVID. We'll see. Remains to be seen on that, but one point just to remain cognizant of. Second, on top of that as well, there's just the general federal contracting compliance obligations that are attendant to any federal contract. There are pros and cons, so obviously associated with all of that should be discussed with internal, external counsel, compliance, HR, IT, finance, sales, executive teams. But again, this may be an opportunity for a number of organizations that had been reluctant to engage in federal contracting before to potentially open up the industry from an opportunity perspective.
So then what's the impact on OCCP audits? We kind of addressed this already by implication. If you have an audit on the CSAL listing, hasn't started, it won't start. Pending audits will be closed per the Secretary's order. Certification won't go forward because it includes 11246. They're probably going to need to be PRA process, public participation process, and OMB approval to change that. That's to be determined whether they keep the certification for vets and disabled in the future. Conciliation agreements, IRCA, those are covered by the Secretary's order. Those are gone. There's an open question whether there's some audit forbearance under the IRCA that would apply to vets and disabled. That's information yet to come. We don't know how the administration is going to enforce vets and disabled. If they move to focused reviews, they probably need to change the scheduling letter through PRA process as well. Brian?
Yeah, also quickly, and we're going to try and wrap up. We've got just a handful of other questions we want to cover, so we're going to go over just for a couple of minutes, and then we need to sort of close with a couple of small items regarding CLE. But just one thing here, what should I do about my 2025 AAP prep for people who are in a calendar year affirmative action plan? I know you're normally in the process of scrubbing your data, getting it ready, sending it out, or doing it internally. Just keep in mind, there is no required Executive Order 11246 Women's or Minority AAP reports this year, and it will not be for the next 4 years. It is over. Veterans and disabled affirmative action plans, yes, you still need to pull those together. That includes the narratives and the data reports. But boy, those reports are a lot simpler and are not quite the heavy lift as required for Executive Order 11246. Also keep in mind, can you continue to voluntarily sort of prepare those plans as before? In theory, yes, you can, but boy, you ought to have a discussion with Bill and myself and Ned and others about that. There are risks that come to that with the new DEI regime. You may have state AAP requirements where you're required to do that, at least for some state contracts, but to the extent that you continue to do this in the same format, it may create a variety of different legal risks to you. And likewise, frankly, you got to ask yourself, and I've said this to several clients, if you're going to run these reports, if you're going to run metrics, A, you want to do it on a privileged basis, but you're no longer regulatory required to do so. And B, why would you keep OFCCP's rotten format that dates back to the 70s? I mean, there are better ways to create affirmative action and reporting. If you're going to do a voluntary affirmative action, let's be more thoughtful about that. I would not default automatically to the current AAP structure. Related to that, Bill, Ned, what do you think? You think this is going to stick?
Well, I do think there's going to be challenges to the certification that you don't have DEI programs, and to the materiality agreement for compliance with federal anti-discrimination laws. The question mark is, well, what is the statutory basis for the White House doing that? The White House historically has turned to the Property Act, but that's where there's a lot of litigation going on, where there's a circuit split emerging, but it does seem like there's some problems for that perspective. It's similar to the blacklisting provisions. They were enjoined by district court in the Fifth Circuit. There's Property Act cases with the circuit split between the Ninth Circuit, the Fifth Circuit as a pending case, and the 10th Circuit over the federal contractor minimum wage. So there is like an opportunity for trade organizations or others to argue that those provisions are beyond statutory authority, and it'd be interesting to see how the courts address those. But it does seem like there's an emerging trend in many circuits against the view that the Property Act authorizes this kind of a order. So we'll see. Politically, it's unclear whether there would be any pushback on the decision of 11246 for a variety of reasons. There's so much coming down from the White House on various different policy areas. There isn't really much kind of opportunity in Congress to push back, and especially given kind of the first 100 days here, it seems like if there's any pushback, it would perhaps kind of become more of get some momentum, later on as things become more tangible here. Ted, any thoughts on that?
No, I agree with you on that, Bill. It's just sort of an interesting mix of these are typically things that the business community have not been in favor of historically. I think there is some degree of interest in the business community. They view this as a positive. So, I think there's an open question about exactly where the pushback is going to come from, at least for some of the things as it relates to the federal contracting space.
Okay, two quick final things. Again, just to keep in mind, as sort of preview coming attractions to come, sort of you ought to expect more aggressive action in this space, both on the state level and on the federal level. I think there's going to be a lot of state actors that try and fill the gap on this. You saw this with pay equity reporting a couple of years ago when EEOC did component 2, pay data reporting. They then stopped doing it, and then a bunch of different states said, this is a good idea, we should do it too. And so they adopted it. We expect to see more of that in the affirmative action space with some states, but keep in mind, they're not going to have the bandwidth, the scope, the regulatory jurisdiction to do the same thing, but it will be complex, and we expect to see that happen. The other thing that we expect to see happen, and I'll be honest here in closing before we go to the CLE slide, you need to be careful about, and I'll be polite about this, affirmative action plan and DE&I vendors and lawyers' clothing. A lot of those folks do really great work, and they can be very helpful as part of a team. But by the same token, you need to keep in mind their business interests are not necessarily aligned with your business interests. And also, more importantly, the work that they do, especially related to communications and reviews, they're not privileged. So be very careful. There's a lot of folks who are going to be looking over your shoulder at DE&I and other activity, and you don't want to be creating exhibits that sort of go against your important legal and other interests. So in closing, we're going to have more webinars about this. You'll get emails about it. For folks who need CLE credit, here's the code. You just need to pull up your phone, and this will link you to where you can fill out information for continuing legal education. At some point on that form, you will see a place where you have to say the affirmation code, and that affirmation code is all caps EOU PDATE. So it's EOU update or EO update. So that's what you're going to have to put into that form. If you have any trouble with that, certainly contact us through the same webinar sort of invite that you got earlier, and Laura Pickard and Jordan Chucker can help you get that taken care of. So with that, that's the end for us. I apologize for going over, but these are hard topics, important topics. Goodness, we've all been working in this space for years. I think the interest of non-discrimination and diversity in general are important to Americans all over the United States, and including the folks here who practice in that space here at our firm, but more broadly, right? This is a big business interest. This is a big national interest. However, this has also been a big debate, and it has just come to the fore. And so just know that we have a whole team of people here across industry who can help you with that. That includes Bill and Ned and myself, but that includes our entire labor and employment, our DE&I team, our affirmative action team, our education team, and all our other sort of industry teams. We're here to assist and happy to do so. With that, I think we're done. Bill?
Give the CLE code one more time, just so everybody can get it here. I see a couple of questions in the box to flag it back up. So we'll leave this one for now.
But yeah, Ned, Bill, anything else you want to add to close?
Just thanks for attending, and let us know if you have any follow-up questions.
Yeah, no, likewise. Very much appreciate everybody attending, and feel free to reach out anytime.
Thank you, everybody. Have a good rest of the afternoon.